Welcome. Thank you for coming out on this not snowy but supposed to be snowy afternoon. Um, Today's talk is Princeton Meets Perseverance, the Fernando Bermudez 18-year innocent prisoner story. And we have two amazing individuals to tell a story that I think was going to put chills in some of our hearts, but will make us realize that in our judicial system, having a process that ensures that innocent people don't go to jail is really important. So I'm really looking forward to today's talk, and I thank you very much for both coming. Fernando Bermudez was wrongfully convicted of murder in 1992, and he served 18 years in prison until proven innocent in 2009. And he'll be sharing his life story with us in this afternoon's talk. And what's, I think, really compelling about your story is that you didn't just stay home with your story, but you're out telling people about it to really ensure that policy changes are made, which is why we're hosting this here at Policy School. He's joined by Rebecca Brown, who's the director of the State Policy Reform at the Innocence Project. The Innocence Project is a national litigation and public policy organization dedicated to exonerating wrongfully convicted individuals. So thank you very much for coming, and we'll get started.
Hello, thanks so much for having us. It's really an honor and pleasure to be here. And I thought that I would just begin my remarks today by giving you all sort of a brief history of the Innocence Project and describe for you what DNA exonerations around the country reveal about problems in our criminal justice system, and then speak a bit briefly about what can be done to enhance the reliability of evidence that's offered in our courtrooms to prevent wrongful conviction. As noted, we are a national litigation and public policy organization, and we're dedicated to freeing innocent people through post-conviction DNA testing. We're often asked, how do you free innocent people if there's no DNA? Many projects around the country are litigating claims of innocence when biological evidence is not available for testing. But our particular office, the National Project, only accepts cases where DNA evidence is probative of guilt or innocence. And so I mention that just to say that there are many wonderful litigators around the country that are also addressing non-DNA claims of innocence, and we have a network of projects around the country that we work with. And we also work with those projects not just to litigate these claims of innocence, but also to try to make changes to the system to prevent wrongful conviction. And right now there are more than 50 organizations around the country that do this work. And from the National Project, we coordinate efforts to do policy campaigns on the state level. As most of you probably know, most criminal prosecutions take place at the state level. So in order to really forge change in this area, we have to go state by state to change the laws and the practices to really make true change happen. This is a snapshot of our cases. There have been 303 DNA exonerations to date, and as you can see, the rate of the revelation of these exonerations is growing exponentially over the last dozen years, and that's because we have now more lawyers dedicated to working on these cases. We're often asked how long people spend behind bars. Some of our cases involve people who spend under a year, but that's infrequent. We have cases of folks that spent more than 30 years behind bars for crimes they did not commit. And on average, our clients spent about 13 and a half years behind bars before they were exonerated. There are actually 18, not 17, of our clients spent some portion of their sentence on death row. So we are often asked, is there a risk of executing an innocent person in the United States? Absolutely, and DNA exonerations speak to that. Also, it's noteworthy that most of our cases involve rape, murder, or a combination of the two, and that is because, of course, those are the kinds of crimes where DNA is most probative of guilt or innocence. But again, I just want to stress that DNA exonerations are just the tip of the wrongful conviction iceberg, and that's because we can only take certain types of cases. Protecting the innocent is a critical and obvious reason to forge wrongful conviction policy reform, but what is often forgotten too is that preventing wrongful convictions also helps to prevent crime, and we've begun to collect data on the actual crimes committed by the real perpetrators of crimes for which our clients sat behind bars. serving their time. And what we now know is that more than 70 sexual assaults and more than 30 murders can be attributed to the real perpetrators of the crimes for which our clients were wrongfully convicted. And these are really actually stunning figures when you consider the fact that DNA is just a small portion of the universe of wrongful conviction cases, and that the figures I just shared with you are convictions. These don't represent the scope of criminal activity that likely the real perpetrators committed, but simply represent those that they were convicted of. So, of course, we're often asked what are the major factors that lead to wrongful conviction. Informant or incentivized testimony was a factor in about 20% of our cases, and I'll touch on that a little bit later. About a third of our clients either falsely confessed, pled guilty, or in some way provided some sort of admission of guilt connected to the crime that they did not commit. And we'll talk a bit later about why that happens and what those factors are that lead to people falsely confessing to crimes they did not commit. About half of our cases involve unvalidated or improper forensic science, and 3/4 of our cases involve eyewitness misidentification. And Fernando was victimized by eyewitness misidentification, and he'll speak a bit about that. So, turning to eyewitness misidentification, how come it's so fallible? Eyewitness misidentification is so fallible because memory is fallible, and memory is also very malleable. And for those that have studied this phenomenon, eyewitness misidentification is totally unsurprising because we know from real cases that eyewitnesses get it wrong more than a third of the time, which is quite incredible when you think about it, because when you watch all of these TV crime shows, we see one person after another sitting on the witness stand saying, "I'd never forget his face, that's the person that did this to me." And what we've learned now from scientific research is that a third of the time people are wrong. And that's just archival studies that really relate to real cases. These are not just studies in the lab. So what can be done to curb the power of misidentification? Well, in the policy realm, we have identified and isolated through scientific research a number of variables that the system can address. And the reason I say that is because there are some factors that we can never address. These are known as estimator variables. For instance, if a crime took place very late at night and it was dark, and say the eyewitness wasn't wearing their glasses, these are things that the system can't really control for. We can always bring experts into the courtroom to describe how these factors might have affected the eyewitness identification that was made. But in actuality, estimator variables, it's very hard to do anything on the system level to address them. So we really focus our work on the policy level on making changes to system variables. And I'll speak a bit about what those are. The single most important reform that we seek is the blind administration of lineups. That means that the person administering the lineup should not know the suspect's identity. And this is a critical reform. And if you think about it, I mean, in any scientific setting, we wouldn't ever, for instance, test drugs during a drug trial, in a pharmaceutical drug trial. Test drugs without, with an administrator who knows the results that they're seeking. We always want the administrator to not know. And we're simply applying this sort of fundamental scientific principle to a criminal justice setting when we call for the blind administration of lineups. And this is how it plays out. What happens when the administrator knows who the suspect is a non-blind administrator. These are 3 different scenarios. In each scenario, the suspect is in the third position. But, say in the first instance, an eyewitness focuses on the wrong person. Well, in that case, the detective may say, well, be sure you're looking at everyone. But if instead the suspect or the witness focuses on the suspect that the administrator would like selected, he might say, well, tell me more about that one. And in the final instance where the eyewitness is silent, he might say something like, I noticed that you paused on the third person. So, and we've seen this in our casework, and I think, these verbal examples are very obvious, but there are a lot of nonverbal influences that also take place and that scientists have really seen play a role in eyewitness misidentification when they've done lab studies and looked at, for instance, the impact of somebody leaning in when somebody pauses on someone or other nonverbal cues. So there are many reasons why blind administration is just a critical reform. Another critical component of a fair lineup is making sure that no one unduly stands out. And how do we know when a lineup is fair? Scientists have come up with what's called a mock witness test. And they give a set of people who have nothing to do with the crime, who didn't observe the crime, who were in no position to even see who the perpetrator was. They show them a lineup, and they say, based on the description that the actual eyewitness gave, can you figure out who the suspect is? And if you look at what a lineup may look like, and this is from an actual case, in this case, the witness described the perpetrator as a white male, about 6'2", with dark hair just over his ears and clean shaven. So when you take a look at this lineup, you see that the individuals in positions 1, 3, 4, and 6 have longer hair. Well, the eyewitness described this person as having short hair. So already, these people are ruled out. Number 5 has a mustache, but the eyewitness described the perpetrator as being clean-shaven. So what we see is that while this is a lineup with 6 individuals, it has an effective size of 1. There's only one person to pick based on the description, and that's number 2. And in a mock witness test, when scientists are testing the fairness of a lineup, what you would expect based on a description is an even distribution of picks across all of the photographs. Because after all, everyone should match the description provided by the eyewitness. But in actuality, you would see a concentration of picks on number 2 in this example. So lineup composition is critically important. Turning to another reform, science has taught us that a confident witness is not necessarily an accurate witness. And we've learned from research that confidence can actually be manufactured. Somebody who's uncertain about an identification that they made, but then receives feedback from the administrator of a lineup along the lines of, good job, you identified the suspect, or you found the guy, you did well. That person's confidence becomes inflated. And so by the time they go to trial, they're on the witness stand saying, I am 100% certain this is the person that committed the crime. And they are not lying. They really come to believe that to be true. So one of the reforms that we seek is getting a confidence statement, a statement of relative confidence at the time the identification is made, to lock in just how confident that person felt at the time that they made the ID. And then later, at trial, if they have a different description of their level of confidence, that's something that can be revealed in the courtroom. So this is just another reform that we seek. So just reviewing briefly, these are just some of the lineup method reforms that we seek. Witness warnings, also known as instructions to the eyewitness, telling the eyewitness that the perpetrator may or may not be present and that the investigation will continue regardless of whether an identification is made, is critically important. It reduces pressure on the eyewitness from making a selection. So if, say, the perpetrator is absent from the lineup, they don't feel compelled to just choose someone. Blind administration, I touched on, ensuring fair lineup composition, getting a confidence statement, and the final reform is sequentially presenting the lineup members. And this is because in a traditional lineup procedure, when you have 6 photos at the same time, what an eyewitness will do is choose the person that most looks like the perpetrator. So if nobody in the lineup is the actual perpetrator, they will just pick the person that most looks like that individual, as opposed to comparing each image in a lineup to his or her mental image of the perpetrator. So when you show them one by one, you're going to get a much better sense of whether it's true memory. And after all, a lineup is just a memory test. So these are all just different prescriptions that we put in place to make sure that the memory test is as good a test as possible. Turning to another reform, a second key reform of ours is addresses the false confession phenomenon. So as I mentioned before, about a third of our cases involve people who provided a confession to a crime that they did not commit or pled guilty. And we're often asked, how could that be? It's a counterintuitive phenomenon, right, that somebody would ever say, I did a crime that they did not commit. There are a number of factors, which include exhaustion, duress, being coerced, the use of force. One that I'd like to focus on is the threat of a harsher sentence. We have many examples of clients who share with us the fact that in that interrogation room, they are so fearful of, for instance, receiving the death penalty, or really being hit with an incredibly long sentence, that they just feel totally hopeless, and that there is just no other decision to make but to just tell the investigator what he wants to hear. And we hear that all the time from clients. They say, I just told him what he wanted to hear. I wanted to get out of that room. I knew we could sort it all out later. And what I find really fascinating about the confession phenomenon is that innocent people do not seek the same protections that guilty people do. They don't ask for lawyers because they don't have anything to hide, or they don't believe that they do. And so what do we do to kind of deal with this confession phenomenon? We call for the electronic recording of interrogations from start to finish. So the minute that the person begins to be interrogated, we want to run a tape so that we can see what transpired in that interrogation room, so that if there was coercion or if devious techniques were used, we can see that. It also can serve a deterrent effect against those kinds of techniques. But even more importantly, and what we see in a lot of our cases, is that detectives unknowingly feed facts about a case to an innocent person. And what happens over the course of many hours is that those facts are fed to the person, and the person parrots them back during the course of that interrogation. And so it seems to the detective that the suspect is providing information about a crime that only the real perpetrator would know. But in actuality, that detective has unknowingly provided information about the case that only detectives would know. So what we've seen is that when we record interrogations, we can go back, we can review the record, and we can see where that takes place. And often it's a totally well-intentioned detective who believes that he's just engaging in a good interrogation, but is actually providing information about the crime to that innocent person. And many states have taken action in this area. About 20 states have either passed laws or issued court orders calling for the recording of interrogations. I'm going to touch just very briefly on improper and invalid science. We've learned that many of our cases involve the use of an improper forensic discipline, or a discipline that hasn't properly been validated. And when I say that, it's that we don't even know the error rate that is attached to how often they get it wrong. So bite mark evidence, for instance, we don't know how often scientists are wrong or forensic analysts are wrong when they get on the witness stand and they say, this is a match from the crime scene evidence to this individual. And so in 2006, Congress tasked the National Academy of Sciences with taking a look and assessing the current state of forensics in the United States. And in many ways, it really sort of revealed that in some of these disciplines, we just don't know how often we get it wrong. And so we need to go back and validate these different forensic disciplines that are offered in the courtroom. And, you know, people are well acquainted with CSI and, you know, all of the different sciences that are offered in the courtroom, but so many of these sciences really need to be better understood, and we need to standardize the way that we describe how strong an association is between crime scene evidence and an individual, because it's often overstated. And so a lot of our work is focused actually on the federal level here to really try to get a lot of federal funding into better validating and understanding these sciences. And finally, incentivized testimony. In about 20% of our cases, someone came forward to say, I have knowledge of the fact that this person committed this crime. He told me about it while we were in the holding cell together. You know, we hear these stories all the time, and it's a factor in so many of our cases. And that's because the witness has often been provided with an incentive. We call these incentivized witnesses. Sometimes it's a monetary reward, sometimes it's the promise of a reduction in sentence, but often it's just the perceived notion on the part of this person that they might get a reduced sentence if they come forward. So nobody's even promised them anything. They're just, you know, really ethical people who want to come forward and help. So we've really, there are a lot of things that can be done to address this. One is really regulating the use of these people, keeping a record of how often these people come forward. You know, there are some of our cases, we have recidivist, incentivized witnesses. So we think that the government should be tracking these people to have a better understanding of just how often they're coming forward. And before using informant testimony, we really believe that the courts should be considering both the reliability of the statement that they made, but also independently corroborating, you know, the information that that person provided about the crime. And these are just some of the questions that can be asked, that the court can ask when determining reliability. You know, what was the relationship between the witness and the defendant? What's the criminal history of the informant? You know, and often in many of our cases, some people come forward years later and recant. They say, you know what, at the time I said this, but I really did a bad thing, and I led to this person's wrongful conviction, and they want to come forward. This is all information that the court should be considering either at trial or in a post-conviction setting. And in determining corroboration, we also, of course, want to make sure that whatever information was provided by this incentivized witness can be independently corroborated in some manner. And I won't go into great detail here, but these are some of the things that the court ought to be considering. So what have we learned from DNA exonerations? We know that there are bad actors, but more often there are a lot of system defects, and sometimes these things work in combination. But we really believe that if the methods are improved upon, if we can do better lineups, if we can tape interrogations, we will just assure fact finders, judges, juries, with better evidence to work with at trial. And the final point I want to make is that DNA exonerations are just a small snapshot of all wrongful convictions, and there are several reasons for that. One is that DNA can only tell us about guilt or innocence in well under 10% of cases, and that's because, you know, if you consider, for instance, a single perpetrator rape, it's very clear where that biological evidence came from. With a complicated burglary, it's difficult to piece together what that biological material can tell you, and often it's not sufficient to prove guilt or innocence. And so what we learn from DNA exonerations is critically important because it identifies the patterns of problems that exist in our system, but we really have to remember and be mindful of the fact that most cases never will benefit from DNA. Which brings us to the featured speaker today, Fernando Bermudez, who is a hero of mine and a dear friend, but also someone who did not benefit from DNA evidence. It wasn't available in his case to test. And so he will speak to you about his story, and I learn from him every day. And we're so thankful to him because Fernando has gone around the country to help make policy change, and he is a true partner in crime, forgive the phrase. So thank you, and if you'd like to visit our website and learn more, please do. Thank you.
Thank you, Rebecca, for introducing me and for the pleasure of speaking to you and everyone here tonight for the opportunity for me to speak from the heart. I'm grateful to Dean Elizabeth Donahue, Patty Yelovic, Lauren Moscow, Jesse Jacobs, and especially Professor Michael Oppenheimer and Chloe Hampson for helping to arrange this talk. I'm also grateful to my wife, my parents, my defense team, and most importantly, God, for helping to prove my innocence after over 18 years in prison as an innocent man. Good evening, ladies and gentlemen. Thank you for attending this event to address the very serious problem of the innocent in prison. Make no mistake, life affords us opportunities to realize how precious it is when contrasted against health versus sickness, wealth versus poverty, love versus hate, and yes, the loss of freedom against the pursuits of liberties and happiness. My crash course in perseverance began in the summer of 1991, at a time when Mayor Dinkins was the mayor at that time, at a time when New York City was a hotbed of crime with over 2,000 homicides each year from 1989 until 1991. It came when I was arrested at gunpoint, a gun placed to my head amid my mother's screams in our Washington Heights neighborhood, a place in Upper Manhattan that mixed the mystical optimism of Dominican immigrants against the allure of fast money. As she screamed, I was placed into a police car and taken to an undisclosed precinct, unaware of the murder charge against me. When I get to the precinct, the police and prosecutor want to know my whereabouts on the night of August 3rd and 4th. Easy to remember, I said. I was actually celebrating my enrollment in college, seeking to enter the medical profession, seeking to atone for past mistakes in my life, seeking to make my parents proud and to contribute to society in some way. My alibi witnesses came forward and attested to our whereabouts. And we were unaware regarding an incident which occurred on the night of August 3rd and 4th at a nightclub in Greenwich Village, Lower Manhattan. By all accounts, Efraim Lopez, 16, on a work release program, and had absconded from his work release program and was in violation of his curfew, had been punched inside the nightclub. Embarrassed, he sought retaliation outside this nightclub by telling his friends from his West 90s neighborhood who had punched him. When the nightclub closed, Efraim Lopez and an approximate 60 Latinos attacked Raymond Blount and his friends who were black. A melee ensued in which bottles flew and fists connected with traumatized victims, teenagers who fled for their lives. And in the confusion of these nighttime conditions, conducive to mistaken eyewitness identification, in that it was fleeting, in that it was nighttime, in that the events happened in such fast fashion that people didn't even know what was occurring, Raymond Blount was shot. I'm oblivious to any of this. With my friends, driving. The neon signs of 42nd Street blurring my eyes as we drove through, and hopscotched throughout different spots, oblivious to what would happen to me 2 days later. At the precinct, I reiterate my position again and again and again, providing more details than a Tom Clancy novel. But I'm not believed. In fact, I'm told that I could call my mother on the condition if I participate in a lineup. I agree, unaware that the perpetrator by these teenage witnesses who had been attacked were hungry, sleepy, and tired, and had been exposed to an illegal identification procedure in which a 17-year-old young lady picked out my picture, illegally shared that picture, contaminating the process. Moreover, the witnesses themselves said that the perpetrator stood 5'10" and weighed 165 pounds versus my 6'2", 215 pounds, which I realize now is the reason why they told me to sit down in a lineup, to hide the height and weight difference. So I participate in a lineup, and there's an eerie feeling that something is going wrong here. And then the prosecutor gets in my grill in an interrogation room, and I keep repeating my story. And he threatens me with 15 years to life if I don't come clean. As a result of me being adamant of my innocence, I'm sent to Rikers Island after I plead not guilty before a judge. Rikers Island is a horrible place. 14,000 inmates, angry, scheming, plotting, attacking each other over the phones just to call, controlling black market operations are all around me. And I'm physically attacked there. I'm beside myself, trying to survive, trying to mind my business, because I'm not a violent person. My hopes are that the American criminal justice system would prevail. And so I exercise my rights as a United States citizen, and I go to trial, believing that my case would be as simple as telling the truth, being patient, and getting freedom. But I'm in for another rude awakening, because unknown to me, Efraim Lopez, the person who had been punched, had cut a deal with the prosecutor in which, as we described as an incentive, he told the police and prosecutor who actually committed the crime. And instead of continuing with the truth, he instead received a plea bargain in which he falsely testified against me, connecting a false name to me that he initially told police and prosecutor. I take the stand. There's no physical and forensic evidence linking me to this crime. My friends come forward and do the same. And in fact, 3 friends of the deceased who were standing right next to the victim when he was shot testify that I'm not the one who shot their best friend. But yet, the fix is in a very broken system, paradoxically. And that's because 2 witnesses beside Efraim Lopez cut a deal with the prosecutor that in exchange for their testimony, their unrelated criminal charges are dropped. So they testify against me falsely as well. And I can't believe when the jury comes back with a guilty verdict. It's beyond me, as I have an eerie outer body experience when I'm sentenced to life in prison. I'm placed on a bus, shackled, with men, angry, fighting. My head is shaven. I'm given civilian prison clothing. In fact, my civilian clothes stripped, and I'm given green clothing with the numbers 928325. And I'm stripped naked in front of a bunch of gawking men, wolf whistling to me. Very embarrassing, very humiliating. And I just try, now that I'm upstate, having survived Rikers Island and the physical assaults there, to get into another stage where I believe I can persevere if I remain patient. I believe I can persevere because the truth is now starting to reveal itself based upon a post-trial investigation in which I obtain a pro bono attorney and a private investigator who starts investigating the West 90s. And they discover that Efraim Lopez had been lying and that the person who he named me as being actually existed, was roommates with him, and lived in his neighborhood. But the judge doesn't want to hear this from this new pro bono attorney, a lady who had actually just earned her law degree in her late 40s with one mission: to prove my innocence. For me, I realize that in the rigors of trying to survive prison, patience is not enough. Prison, surviving prison, can be compared to fruit salad. You're going bananas because you're surrounded by nuts. Yeah. In a bowl of pits, not cherries. You have to become a peach, allowing insults to fly off, eating humble pie when necessary, so that you won't get a knife in your neck from some delusional inmate. You look for, within that sea of misery of prison, for that prickly personality, which is like a pineapple, yes, but has that sweet interior, who wants to become your friend and wants to help, but wants to keep a facade for fear of looking soft. You have to act, become a pomegranate, plucking hope one day at a time, one nutritious seed at a time to survive. Because in prison, 24 hours seems like 48. In all, it comes down to, how do you turn lemons into lemonade? And that comes from attitude. That comes from an attitude of transcending what is going on in your life at that moment. It comes from transforming grief into action. Because let me assure you, grief is not a trip you can pack for. For me, I was able to change my circumstances through the power of education. I realized that I needed to educate myself early on. I needed to learn the law because the legal team that I had was not able to accomplish a victory. And so I started learning the law, going to the law library. I earned a college degree while there, an associate's with a concentration in business. I would exercise, running the yard to clear brain fog, running the yard so I can stop my hands from shaking from the anxiety that living in a 6 by 9 foot cell, roach infested, with a correctional guard passing by every few hours to check on the suicide rate. Living in prison is like living in a postcard. You have no privacy. The world is there. Everyone can see what you're doing. Even using the bathroom is a public thing. One of the things that kept me going was love. I believe that our Creator gives us hands with the spaces in between so that another can put them in between. The deprivation, the loneliness that I felt for years was stopped when I met my wife, whose hands went into mine, and with her hands came the hands of little children, our children, born out of the adversity and desperation of our circumstances, with the faith that we would persevere. But the problem is, I'm in prison as a dad, writing letters to my daughter, helping them learn how to read. What am I going to do? I'm in prison. So I develop an idea using my business skills. I become a prison haberdasher. I start buying clothes wholesale, and I start retailing it in prison. The clothing I sell for $5 is sold for $20. I don't get cash. I get detergent, toothpaste, soap, anything I can from the prison commissary, stamps and cigarettes, etc. And I take that all in lump sum so that when my wife comes to see me on our private visits for 3 days, the only escaped moments that we have from the grim realities of prison, I give it to her, and she in turn takes it to Kona Bodegas uptown in Manhattan and exchanges it for cash so that she can prevent near homelessness, so that she can help our children receive Christmas gifts because daddy's not home. I realize that this can't continue because I can't sell clothes fast enough to help my wife survive, nor myself in trying to be self-sufficient, despite my prison kitchen job in which I'm the only inmate or prisoner entrusted to work in a civilian office. By 1999, the reality of getting out of prison is more pressing than ever. By 1999, when, if I recall correctly, the Naked Olympics were banned at Princeton, I had lost all my appeals, failing to cross the finish line of the hope and faith that I had exercised up until then. What was I going to do now? I continued writing letters. I continued trying to get attorneys to help me after my pro bono attorneys at that point failed appeal after appeal. I realized that my crash course in perseverance needed to continue, needed to overcome the opposition that I continued facing in my life. And so I continued writing letters to attorneys who could help me. I was inspired by the Dreyfus affair, in which a man was wrongfully incarcerated in France based on anti-Semitic grounds. until his innocence was proven, with advocates such as the famous writer Emile Zola, who came to his aid. And I said I needed to get my own team. And I did. We got a team that started writing so many letters that we got the New York Times to cover it front page. MSNBC, Court TV aired an hour-long documentary by 2005, 2007, and 6. And then I landed another attorney from New Jersey proper, who said, I have an idea that you can use a previously favorable proceeding which did not result in my overturned conviction to your favor. In 2002, I had entered federal court before a different judge, and this judge agreed that the identification procedures in which the teenage witnesses were involved in was illegal and should not have happened. Yet he stopped short of overturning my conviction at that point, because under federal law, even though an identification is suggestive, he can still rely upon the identification as being reliable based upon what the witnesses said at trial. But what the witnesses said at trial was totally different than what they were saying before him, because by now they had recanted many years ago. But it didn't matter. And so I continued writing, and with this attorney, she got more attorneys. And I wrote more attorneys. And suddenly we had attorneys from Washington, D.C., New York, and New Jersey law firms. The Innocence Project joined me as well. Centurion Ministries from Princeton, New Jersey, nearby here, joined me with an amicus brief. And together we entered state court, hopeful that this case will be resolved. By 2008, with the team I had amassed, our proceedings began. And the judge, Justice John Cataldo, a new judge, gave the prosecution an opportunity to investigate. Yes, 18 years too late. And he did it, it seemed, because he wanted them to hang themselves. And they did. Because when they investigated, I should say, what they found was evidence that was more in my favor. The person who was named by Ephraim Lopez as being the actual perpetrator was discovered to have fled the state after the murder, was living under an alias, traveling around the country and getting arrested, and when pressed for an alibi on his whereabouts on August 3rd and 4th, it was like Swiss cheese, full of holes. Based upon this, the prosecution grew nervous. They offered me a plea bargain in which if I pled guilty to manslaughter rather than the second-degree homicide conviction for which I was serving a life sentence, I can go home that week. And by 2009, as my proceedings were about to begin and I had this Faustian bargain, this deal with the devil before me, I said, no, I'm not going to do that, regardless if I have to die in prison. Because the risk was that if I lost this 11th appeal, because by now I had filed so many appeals that I could probably wallpaper the Manhattan courthouse with so much legal work. And yet I refused. I would prefer to die in prison than accept guilt for something I didn't commit and allow this mark of Cain to remain around my neck for life, as it still would. So I rejected that. And I went to court. And I entered court hopeful that I did the right thing, after my wife and I prayed, cried, and believed that this injustice would come to an end. And I entered court 2 weeks after my 2-week proceeding, my 11th appeal. And here it was as I entered a packed courtroom before this judge, who behind his bench had "In God We Trust" as one of the few courthouses that still proclaimed such. And I walked in nervous, feeling all goosebumpy, I must admit, because here was my life. Here was a decision that could make or break my freedom. Would he issue an Emancipation Proclamation in my life? The judge silenced the courtroom. You could hear an eerie whir of media cameras and photographers furiously scribbling to capture the moment. And he asked me to stand. And I stood with my attorneys. And he said, I hereby declare Fernando Bermudez actually innocent. And the courtroom erupted in applause, a punctuating sigh of relief from my mother, who had suffered so long, from my wife, from my little sister who was 6 and was now in her 20s. And I couldn't believe it that I was a free man. I was so happy, this time having an out-of-body experience, which felt good this time. And I went out to a world after over 18 years, 6,700 days of my life for a crime I didn't commit. And I was confused. Man, I was confused. The world had changed so much. The cell phones were this big when I first went to prison, now they were this small. It was a brave new world of technological changes. People were talking to themselves, and it turns out that it's Bluetooth technology. I didn't know that. Fashion had changed. Somebody threw me a pair of jeans and said, throw these on, dude, they're skinny jeans. And I hopped into them like it was a potato sack race. And when I felt uncomfortable claiming they were leotards, he said, that's the style, dude. And I said, I don't know about that. I came home to Washington Heights, and I had my first Big Mac. Then I went home and I had my wife and my mother's cooking, which tasted better than ever. And my children all jumped on top of me. My daughter, 2 daughters, and my son, who was 3 at the time. And I couldn't believe it that I was free. I went for my first run in Inwood Park, in Upper Manhattan, free. And yet, I was having problems. The problem that I was having, I would realize, was that I woke up as if I was still pacing in a prison cell. I woke up as if I was still being counted like a prisoner. Crossing the street was an issue. Holding money felt like something foreign to me. I would get up and my wife would tell me, get back to bed. This is not a cell anymore. And that's because I got used to all of this. I was hypervigilant in department stores, thinking I would get stabbed around so many people, because in prison, you try to stick your back against the wall because you don't know what's going to happen. We're dealing with combustible personalities, and it still felt like that was happening. So I started seeing a psychologist, and I began pursuing my college dreams. College dreams which began in 1991 and continued in fits and starts in prison, and last May resulted in me obtaining my bachelor's degree, summa cum laude. And I've decided to use my educational background and my experiences to help humanity. I started working to abolish the death penalty in my state of Connecticut, resulting in an opportunity to get invited to Rome, Italy, where I spoke throughout the country. And as I stood before the Roman Colosseum, that ancient backdrop to address the modern problem, that the death penalty should be abolished worldwide, I looked amazed at the crowd, and I thanked God for taking me to a place that I never envisioned, yet a place that I knew I had to work for and persevere to obtain. And it happened because I worked with state legislators in Connecticut to help abolish the death penalty, giving testimony as much as I could. There is a problem, ladies and gentlemen, with the system. The system is beyond the effects of post-traumatic stress disorder affecting individuals like myself who've been wrongfully incarcerated. The question is, from stockade to guardhouse to places of mass incarceration like Sing Sing Prison to San Quentin, the question is, how often does the system get it right? My dear audience, not enough. Not enough, because as pointed out by Rebecca, we have over 303 DNA-based exonerations in America, with many more non-DNA exonerations like myself. The toughest cases to crack. We have a situation where since 1973, over 100 people have been released from death row, with strong evidence to indicate that innocent people have also since been executed, whether it's Cameron Todd Willingham in Texas, or whether it's Troy Davis in Atlanta. The grave, irreparable risk of wrongful convictions and the death penalty is that once it happens, you can't take it back. DNA, as pointed out, can only resolve 10% of all wrongful convictions. Experts estimate that the problem with wrongful convictions, judging by 2.3 million people incarcerated in America, is as high not only as 5%, but what it translates into is tens of thousands, if those numbers are correct. So this is a very serious social problem. A problem that wastes taxpayers' money through the millions of dollars that are earmarked to pay for the wrong incarceration, and the millions of dollars that are needed to compensate people who are innocent in prison. And of course, the problem also is that when an innocent person is incarcerated, the guilty are out to wreak havoc, potentially. And as pointed out, the greatest problem, the leading cause of all wrongful convictions is mistaken eyewitness identification, which took me so long to be able to finally prove with overwhelming evidence that it wasn't me. I believe that we would curtail some of this problem of wrongful convictions, unjust incarceration of innocent people, if prosecutors were held accountable. To date, prosecutors are immune from civil liability, unlike the police department. They are good prosecutors in the same way that they are good police officers. And they are to be cherished, those who do the right job. But for those who flout the law is another issue. And if we were to hold them accountable in civil proceedings, we would see a decline with such problems, such as late disclosure of favorable evidence, such as coercing witnesses, such as what happened in my case. Because the judge in his ruling not only said that the state had relied upon perjured testimony, but that the prosecutor knowingly used false testimony to secure my conviction. Apart from the state admitting for the first time that Efrain Lopez had committed perjury, which up until then they had denied. So it's a problem that needs to be addressed through accountability and through improved reformative measures that Rebecca Brown has cogently pointed out. I believe that we can leave here today empowered with the idea that we can do something about it. We can write letters, we can join and volunteer innocence groups to help in some way in this place of great privilege. Our 28th American president, Woodrow Wilson, lends encouragement, ladies and gentlemen, when he advised, "You will not hear merely to make a living. You are here to enable the world to live more amply, with greater vision, with a finer spirit of hope and achievement. Ladies and gentlemen, you are here to enrich the world, he said. And you impoverish yourself if you forget that errand. My errand, ladies and gentlemen, is encouraged by an ordeal that could have killed me, but today keeps me alive. This is why I speak for the innocent in prison. I speak for those who champion social justice, like Rebecca Brown and the Innocence Project. I speak for those who want to do better, but don't. I speak for families affected by the travesty of wrongful convictions and the toll that they exact. I speak to change the world, to use my story of perseverance by changing grief into action, which I encourage you to use whenever something confronts you in life, any difficulty. I thus agree, in order to prevent what happened to me from happening to others, with Woodrow Wilson when he adds that our American history is a history of resistance where liberties are concerned. Which is why I implore everyone to get involved with innocence projects in New York, in Centurion Ministries at 221 Witherspoon, not far from here. And in doing so, you can all join me to resist unjust convictions. For when we do, our humanity shines, brighter in moments of consciousness against the darkness of human error, apathy, and evil. To instead persevere in our nation's service and in the service of all nations, to make this world a better place and prevent the public safety and human rights violations which changed my life for better and worse. Thank you.
So I don't think anyone's ever going to say the Woodrow Wilson quote ever again, because they can't nail it the way you just did. So thank you very much. We're going to take questions from the audience. I'm sure there's many. Raise your hand. Don't be shy.
Hi, Fernando, thank you very much for telling your story. That was really incredible. I have a question for either one of you. It seems like some of the interventions that Rebecca was describing would be fairly uncontroversial, like the blind administration of the police lineup. So I'm wondering what the opposition or the obstacles are to implementing some of those things.
Could you repeat the question, please?
So it seemed like some of the suggestions that Rebecca was making in her PowerPoint wouldn't be that controversial, like having a blind administrator for the lineups who didn't know the suspect they were looking for. So I'm wondering why those things couldn't just be implemented now, or what the barriers are, or where the opposition is coming from?
Well, I think the gravity of wrongful convictions and their toll has now been realized even more. There's been so many exonerations that now it's like, well, what's happening here? We got all these lawsuits. We have all these people who've been changed forever for the worse in many ways. And we have to do something. Looking back, there was not the same advanced awareness that there is now. I mean, there were antiquated legal systems, which were, for example, in 1994, 1993, and so forth, were introduced in New York City Police Department, which now help for more accurate measures in terms of database collection and so forth. In other words, they just realized that certain procedures in the past do not work and they need to be changed, taking heed from other places, such as even New Jersey, which has enacted identification reforms. So it's a growing groundswell of support in which, well, we have to get on the boat as well and do something, because our past methods have not been working, and social sciences have been demonstrating what are the actual causes.
And I mean, I think, you know, to speak to the barriers, I mean, there are many. I mean, first I should say New Jersey was the first state in the country to implement blind sequential procedures. So it's been a national leader on that front. Not just on that, but also New Jersey does record all custodial interrogations. So it's to be commended. But in terms of barriers, I mean, I think, you know, there's the natural human nature barrier of somebody coming into your shop and telling you how to do business, right? I think a lot of law enforcement, when we work with them, you know, often will say to us, you know, we understand that misidentification is a problem, but we're not being suggestive. And, you know, and one of the things detectives often say to me is, if a second administrator, meaning a blind administrator who doesn't know the suspect's identity, is performing the lineup, administering the lineup, he doesn't have rapport with the victim. And I don't want to lose that rapport. And maybe she'll clam up or be scared or she won't make the ID. There's no scientific evidence to support that. But, you know, that's been an issue. Another issue is with blind administration. They say it's a manpower issue. You know, if I'm in a small department with 1 or 2 officers and I need a second officer to administer a lineup, it's very difficult. And actually scientists have developed what's known as a folder shuffle technique, where you put lineup members in manila folders and shuffle them and present them to the witness one by one, to effectively blind yourself, so that you're not in a position to provide suggestion if it's done properly. So, you know, we've gotten around some of the cost concerns, but those are just some of the things that come up. I think the biggest issue often is just resistance to change, which any one of us is capable of in our own field. I mean, we just got a new computer program at work that's driving me crazy. And I just am like, can't we just go back to the old way? You know, and I think that it is a human nature issue. And I think, you know, the policy realm, it's one of the hardest things to overcome. Because, you know, because the people who are performing lineups say, we're the ones who actually know what it means to do police work. You're just an advocate. What do you know? And so those are some of the things that we have to overcome all the time in our work. But, you know, many states are really moving in the right direction and embracing these reforms.
So I have just a follow-up to that, a jurisdictional question. In terms of where did these policies come from? I mean, it's state by state because it's criminal law, but are these things that state legislatures have to grapple with, or are these simply procedures that at administrative level, the head of the Justice Department or whatever in the state could change? I mean, who has to implement these, and is it different state to state?
It is different state to state. So, you know, for instance, you know, in recording of interrogation, some of the states record interrogations because the high court says we won't accept an unrecorded confession, or preceded by a recorded interrogation. On the eyewitness front, I mean, more often than not, we really need to get legislation happening. However, you know, there have been a lot of forward-thinking, enlightened police chiefs who have just implemented this on their own. In fact, you know, we know of huge cities that have Dallas just did it on its own because they were, you know, the chief read about the social science that was out there and said, look, this is the right thing to do. And, you know, one of the things that I always find incredible is the resistance in light of the fact that the package of reforms that we see really reduce non-suspect PIPs by about 50%. So in fact, it actually aids criminal investigations to get the right person as early as possible. But often that's not what they're doing. And so to better answer your question, legislation sometimes it's, you know, a policy change made by an individual chief. Sometimes, you know, it's a decision made by the court. Sometimes courts will say, we're going to issue jury instructions to address any deviation from best practices, and that will then compel change on the local agency level, because agencies say, God, if we're going to get a jury instruction, we better just get this right. So lots of different ways.
I mean, the only reason I ask is that you'd imagine that politics would come into the play a lot more if it's at a state legislative level than if it's just an administrative rule that you're seeking to change.
There's no question, and I mean, I think especially in the eyewitness, I mean, it just requires incredible leadership. I mean, former Attorney General Farmer, who has, in New Jersey, the AG has plenary authority over all the law enforcement agencies in the state, which is totally unusual. It doesn't happen in any other state. So he just really took on a leadership role and said, you know what, I've read the science and we're going to just do it this way. Otherwise, you know, to get uniform adoption, we generally have to go to the legislatures, and it's very difficult.
Yeah.
Your harrowing story brought what might be thought of as a good Hollywood drama to life for me. So I'm one thing I hear from this is that, you know, the prosecution had to work awfully hard to get you convicted. And sounds to me like the system is broken in some sense. So, I mean, to stop unfounded prosecutions going internal, I mean, who knows what the motivation of the prosecutor was to work awfully hard to do this? And could there be some kind of prosecutorial committee system that would actually review? I mean, these are important cases, murder cases. So I don't know how to, somehow you have to diffuse a rogue, some guy he needs this prosecution because he's going to retire next year, right? He needs something under his belt. I don't know what the motivation is, but your description, it doesn't make sense that you were prosecuted. So I don't know, somehow you got to get inside the system and spread the decision somehow. I don't know. That would be something.
Yes, I mean, absolutely. I mean, our law in part is based upon deterrence. Deterrence to enact laws to deter people from committing crimes. And that deterrence should be enacted against a prosecutor who violates his ethical responsibility, which he vows, in the same way that perhaps a doctor would his Hippocratic oath, and the same way that many industries across America, ranging from the medical field to the aviation, are held accountable if they mess up. And so if a human life is played around with in the way that mine's was, and in the way that other lives have, you know, in countless measure that we have, you know, it should be dealt with. There should be some adversarial process that addresses that shortcoming, because if police departments are accountable, then it stands to reason that if a prosecutor was held accountable, they would think twice as well. So that there needs to be something where they're held accountable. In very few instances, very few. One example being, for example, a double cross case in which those men were prosecuted unlawfully, and then the prosecutor was fired as a result. You know, it's just one glaring exception that happens, and that's perhaps, I dare say, in part because they came from such wealth and prestige, versus me or many other people of color who get put to the system for lack of resources, who don't have money to fund bail or anything like that, who just get sent to the system. So there needs to be accountability, and we would see a great change, rest assured.
And I think there are so many human factors, right? I mean, I think there's no real system encouragement of clearing innocent people, right? I mean, there's just a huge emphasis placed on getting convictions. So I think, you know, from a policy perspective, it would also be very interesting to examine ways of incentivizing prosecutors' offices to clear the innocent as well. And I think we don't have a system that's built around that.
The way of a recant. I mean, he coerced testimony versus, okay, I lied actually. But getting off it is much less accepted than it's a one-way street, it seems to me.
I mean, Troy Davis, 7 out of 9 people recanted, and he was still put to death. I mean, we see this all the time.
So they were having an issue on his wife, they were having an issue in his precinct that they were having trouble closing cases. So there may be another reason why they went after Massanova and all of them went after Fernando. Because they already had him in there for the problem, and then they even fought really hard to keep him in there. They didn't even want to open the doors. And also what happens is he kept going to the same judge, and the judge seemed like he was in bed with the prosecutors. Like he wasn't, and also with the police. He wasn't trying to even allow evidence in. So he fought him tooth and nail until he retired. And then there was another judge. And there was fairness there.
For example, the prosecutor on the eve of my jury selection, when it began, turned over boxes of evidence. Too late. This prosecutor, James G. Rodriguez from the Manhattan District Attorney's Office, who at that point was a veteran prosecutor, had no reason to do that except to handicap my defense. And then when my attorney got hold of that evidence, he requested the judge for a continuance, which was an adjournment to inspect the contents, and the judge refused. He said, this case has already begun. Let's move forward. It's not right.
Yeah, you know, I'm familiar with prosecutors, not fortunately because I've been convicted by them, but the fact of the matter is that we do know that they advance their career by having a lot more wins than losses. And quite frankly, I think that's more important to their career than achieving social justice. And I hear what you're saying theoretically, and as instructors before us, and what you say is very lightening, but I only suggest that you take it to the next step. And I'm not hearing that yet. I think you need to get a team of people together and craft some new legislation. You need to change public policy in the ways that you know it needs to be done. I don't know the exact wording, but I think it'd be such a shame if you leave this forum and then you don't take the next step and make something really happen.
Sure. I'm doing everything I can within what's humanly possible for me and my post-traumatic stress condition to address everything. I mean, working, I depend on public speaking to earn a living while I continue my other, options in life, and, a father full-time, and in doing so, I'm still here for the cause with Rebecca, and we have plans. Us, along with other Innocence Network, are going to do many things.
And I guess I didn't form a question, may I just say,
And I'm supposed to reprimand you now.
The Innocence Project, is it possible that you could draw together some people from the AG's office, a legislator, and sit down and bring Fernando and discuss, maybe a summary version what transpired, and put something together? I'd be glad to participate as well. I've got some experience writing policies and changing policies, but in any case, that's my question. Does the Innocence Project see some hope? And will you take steps for this very noble cause?
Is the question, are we taking steps to address prosecutorial misconduct?
Yeah, and well, to bring about the accountability that's ringing loud and clear from Fernando's voice, crying out for change.
Absolutely, and I mean, we've actually recently there was a national tour that addressed the issue of prosecutorial accountability, and there's a report that's soon to be issued with a set of recommendations around that. I think a very critical component of reform in this area is what's known as open file discovery. In other words, making sure that the defense has access to the evidence before the eve of a trial when no one can do a fair investigation. And so, this is critically important to bring to the table, and it's certainly something that we focus on in our work. And, North Carolina actually has been a leader on that issue. They passed an open file discovery law years ago that did grow out of a wrongful conviction case, and often and sadly change has to happen because a tragedy or a miscarriage of justice is taking place. So it's certainly something very much on our radar, and it's something that we're working on around the country.
First of all, thank you so much for coming. This is a great talk. I'm curious about work that's being done to prevent, to let at-risk youth know their rights. And I'm curious if the Innocence Project does any work surrounding that so that they know not to make the mistake that many people do make.
Well, I travel and I speak to at-risk youth as well, because there's an issue there with elements of beyond them getting trapped into the system, peer pressure, drug and alcohol abuse, lack of education and meaningful opportunities within inner cities and things like that. These individuals, people of color, most prone to get arrested. And so I go to high schools, I go to many different venues and I speak. I've even spoken in federal courthouses by invitation of federal judges to speak to men who've been convicted yet want to change their life around and are in a program to help them change their life around despite their convictions, in which I encourage them to stay on the right path. So we're doing something to reduce recidivism in that respect or prevent any incarceration.
And I think one of the issues that I raised earlier, which is I think really a public education issue, particularly if you're an innocent person, is that when you are innocent, you don't seek the same protections that guilty people seek. You don't ask for a lawyer because you think it'll be fine. You didn't do anything wrong. And so I think, one of the things that we all need to educate ourselves about is the fact that wrongful convictions happen with much greater frequency than any of us believe. And, and that none of us is immune. And I mean, I think there are absolutely certain communities that suffer more, communities of color, people with less means. I mean, these are people that are going to be much more vulnerable to but, there are many examples of, completely, people of means and people that get wrongfully convicted all the time, and that happens, we even have an exoneree who was a police officer. And so, these things happen, and so I think people really need to come to understand that, in any sort of setting where you're innocent and you're being questioned, you want to get a lawyer. And so we do extensive public speaking. A lot of our staff speaks at public schools, and so we do attempt to do some outreach. But I think a lot of this is just about general public education about about wrongful convictions.
Okay, yellow shirt.
Sure. I'm curious how you've been responding to pushback among individual prosecutors who probably don't want civil liability because they fear it might make them too timid, they might not go after powerful defendants who could just go ahead and sue them afterwards. I'm just curious how you're balancing that concern.
Well, the thing is that it seems that the system, in part, is shielding them for that very reason, because they want to, encourage prosecutors to do their job. But the thing is, what is a good job? Famous Supreme Court Justice George Sutherland stated that the prosecutor is allowed to strike hard blows, but not foul blows. And when you strike a foul blow, it undermines what our American criminal justice system stands for, which is fairness.
Okay, so we're going to take one more over here.
Thank you for sharing your story with us. Outside of a policy perspective, but from a personal question, I'm curious as to what lessons this whole ordeal has taught you. What have you come away with this learning?
It's taught me perseverance. It's taught me not to give up on my hopes and dreams. It taught me that even though I lost 10 appeals, which, at that point, the odds of success were remote and painstakingly psychological, that I needed to continue fighting because I held on to the truth. And I needed to continue making a way for myself after prison, because under my conditions and still trying to adjust, I needed to find a way to support myself. And I said, you know what, I'm going to use my story for a greater good. And even when I call places and so forth and I don't get accepted, I persist. I called Princeton University at one point and one professor ignored me. But now look, perseverance. I'm here today. I don't give up. And that's why my story has gone international. Next month, I'm in Germany, 14 days speaking. Then Japan in October, because I'm not going to give up. The breath of life has been breathed into me. And my wife and I and our children, my daughter wants to go to Yale, and in Princeton for her undergraduate. Yale Law School is.
Oh, okay.
Are a team. We are a family that fights together and stays together through the power of the truth that helped us secure our victory.
Okay, I think we're going to end there because can't get better than that. So thank you very much for everyone.